morning, everyone. And I had a few words prepared, but I knew it would be hard to follow Professor Frédéric Geny. I guess I didn't realize it would be that hard, so I'm tempted to say the session is over even before it starts, but I think we should do our best to follow up on Fred Geny by having a very interesting and engaging intellectual discussion, and nothing better for that than discussing vertical restraints in e-commerce. I know the topic might sound boring, but it's actually, honestly, extremely interesting. And just before saying a few general words about e-commerce and about this more general topic of the digital economy, which was, of course, very much mentioned both by Fred Geny and by Antonio Gomes, these topics have been at the core of the OECD work. Just in the last 3 years, we had many discussions by the OECD Competition Committee about algorithms and collusion, big data, disruptive innovation, blockchain, you name it. If there is a topic, a competition issue in digital markets going on, most likely the OECD Competition Committee has looked at it. And if not, probably it's looking at it right now. Fred mentioned the decision about the AT&T and the Time Warner merger, and indeed we are looking at vertical mergers right now in the TMT sector. Last year we had a discussion on the implications of e-commerce for competition, and this topic of e-commerce is a giant box. If we open it, many things come out of it: abuse of dominance by online platforms, hub-and-spoke cartels, horizontal collusion, and of course, vertical restraints, which to date are the #1 area of antitrust that has seen the greatest amount of enforcement. And then if we open this still big box of vertical restraints, many things come out. Exclusivity agreements, retail price maintenance, and so on and so on. Now, each of these topics are a Pandora's box on their own. They are extremely complex. They are probably some of the most complex issues that we have worked, vertical restraints. And today we are going to try to open 2 Pandora's box. The first, selective distribution models, and the second, most-favoured-nation clauses. Now, they are very hard, but we are lucky because we couldn't count with a better panel of expert speakers, which I'll now introduce. So, here to my left, first there was a small change. We would count initially with Birgit Krueger from the Bundeskartellamt. Due to a last-minute change, we were very lucky to be able to replace her, so we lost a star, but we won another star. And we have with us Gunnar Kalfas, and he's the head of unit for German and European antitrust law in the General Policy Division of the German Bundeskartellamt, which, by the way, is a prestigious competition authority with a lot of enforcement experience in this area, so we are very lucky to have Gunnar with us. And before his current position, he was a legal advisor in the department dealing with litigation and legal issues, and case officer in the 6th Decision Division, which, by the way, is responsible for media and sports. Now, to my right, at my right, we have with us Professor Pinar Akman. She's professor of competition law and director of the Center for Business Law and Practice at University of Leeds. Now, I have here just a few information that Pinar was, in the last 3 years, shortlisted for the antitrust winning awards. And there is a prize that she won. That prize is the Leverhulme Prize. I hope I said the name right, and sorry to read this, but this recognizes the achievement of outstanding researchers whose work has already attracted international recognition and whose future career is exceptionally promising. So, Pinar, thank you so much for joining us. And finally, we count also with Dr. Paolo Buccirossi, who is the director and founder of LEAR, a specialized economic consultancy in the fields of competition policy and regulation. And apart from the many publications of Paolo, he has been engaged in economic advising and in economic research with many public institutions, the European Commission, the World Bank, several competition authorities and governments. And I believe that to that list we have to add the OECD, because I remember reading one of our reports that was written by you. So it's a big list. So thank you so much, all of you, for joining. Now we I'm going to structure this discussion as a conversation, which means that now I'll shut up myself and engage in a conversation with all the panel speakers. And so I open now the part on selective distribution models, which are basically vertical agreements through which a supplier restricts the number of authorized distributors. I hope I did, I think this definition comes in one of your papers. I hope I did it right. And Paolo, I will start with you. The main objectives, as I get from the selective distribution models, are to promote, to guarantee the reputation of a brand, to create incentives for the provision of pre-sale services, to promote investment, etc. But I understand that they pose a major competition concern, the reduction of intra-brand competition. And in the case of e-commerce markets, what happens many times is that these suppliers basically try to prevent the distributors from selling online to avoid online competition, which can be very fierce. And so my question for you is, in light of this risk of restricting online competition, are there any efficiency gains that could justify the use of selective distribution models that restrict online competition?
Okay, Pedro, thank you very much for your question. Before answering that, let me thank also the OECD and the organizer of this conference for inviting me. It's a great pleasure and honor to be here with such an audience. All right, your question is very complex. I mean, we have to step back a little bit and to understand what are the efficiency reasons to have a selective distribution system in the first place. And you're right. I mean, a selective distribution framework means that there is a vertical arrangement, and this means that there are at least two markets, retail markets and an upstream market. And selective distribution is a model that is used for differentiated products. So this means that there is price competition and non-price competition. And both forms of competition take place at both levels, at the retail levels and the upstream level. Now, the main reason why a selective distribution system can be efficient is that it induces a different balance between price competition and non-price competition at the retail level. And this can lead to a situation where consumers are better off. Now, I believe that the economic foundation for this efficiency is not really that for some markets, let's say, quality is more important than price. That would be a very dangerous statement. But it's rather than, the decision to achieve this different balance is taken by a firm that operates at a different level. So there is generally a vertical externality, and the vertical externality has the same sign if you go from the retailer to the consumer, and if you go upward from the retailer to the upstream producer. And so this means that the interest of the upstream producer is more aligned with the consumer interest.
But Paolo, if I may ask, do you think it could make sense to promote some kind of quality competition at the cost of price competition in this context of vertical restraints? Because I think courts would never accept that justification, for example, in the case of horizontal collusion. Companies cannot say, oh, we are colluding on prices just to guarantee that we'll provide a service with high quality.
Good point. Yes, definitely. If you have the interest of coordinating on quality, or coordinating on price to achieve more quality is just a decision that is made by, the retailers, we should be very suspicious. At the same time, courts do recognize that quality might be more important than price competition, and indeed we have several judgments by the European Court of Justice in which this is clearly stated. And it's stated in a way that, it gives a presumption that such an arrangement doesn't conflict with Article 111, which means basically that it doesn't need to be an exception. It's compatible with competition. It's a way to compete. It's a genuine way to compete.
In terms of the quality dimensions that could be appropriate, so I did my homework and read a few of your papers, one published in the European Competition Journal and the other in the Journal of Competition Law and Economics, and you discussed there many of the cases that have shaped the EU position in terms of vertical restraints, and I'm talking about the Metro case, the Pierre Fabre, the Coty case, and please correct me if I misunderstood, but I had a feeling that you had some criticism with respect to the Pierre Fabre, because at that point, basically the Court of Justice said that maintaining a prestigious image is not a legitimate purpose for restricting competition. So do you believe that maintaining a prestigious image could be, in certain circumstances, a purpose to restrict competition?
I do believe that this is a choice that the competition authority are not well equipped to make. I mean, it's much better to have firms making this kind of decision if the brand image is crucial, is important for consumer welfare or for the functioning of the market. That's something that firms do understand, whereas competition authorities lack the expertise and the real sense of how the market works.
If I may move now to Pinar to ask her a question, because you have a lot of experience also in this area, and something that through all this reading and research that many times is criticized or discussed is the fact that in the European Union there is some tendency to try to identify which are the circumstances that are per se legal, the ones that are per se illegal, and we can see that in all these cases and also in the recent Inquirer of the e-commerce sector. So, for example, a total ban on the use of the internet is per se illegal, and the same is true for price comparison tools. You cannot ban, so suppliers should not ban their use. But on the other hand, in some occasions it might be okay to restrict the use of a marketplace. For example, if there are concerns of preserving the image, and I'm of course talking about the Coty case. So what's your position on that? So what do you think about that?
Was that one question?
So basically, do you agree with this per se approach to many vertical restraints? To make the question short.
Thank you. And thank you to the OECD Competition Division for the invitation. I'm delighted to be here. I think you put your finger on exactly the hot spot here. What seems to be happening is that at the moment it's not entirely clear what sort of restrictions on sales on the internet will count as hardcore restrictions and what type of restrictions on sales on the internet are not hardcore. And the Coty judgment and the essentially juxtaposing of the Coty judgment with the Pierre Fabre judgment still leaves a lot of questions in the air. So I think the court is quite clear in Coty's explaining Pierre Fabre in saying, okay, what we tried to say in that decision was that you can restrict competition by adopting a selective distribution model in the first place, because adopting a selective distribution model restricts competition to begin with. You already restricted the sales channels. But once you have restricted competition in that way, you can't further restrict competition by also banning sales online. So that's how the court interprets in Coty its own Pierre Fabre judgment. But if you're doing it in another selective distribution system where there isn't an entire sort of total ban on sales online, and you're only doing it essentially to further protect the aura of luxury of your product, and the online sales place is a marketplace which is not particularly luxurious, then essentially the quality enhancement that you're trying to bring with your selective distribution model justifies that ban, because if your products are sold on marketplaces which are not as luxurious as your product, according to the court at least, that seems to prevent a problem to the manufacturer in terms of preserving the quality image, which is what justifies the selective distribution in the model, and therefore that sort of restriction is justified in the same way that the court says, okay, the selective distribution model is also justified. That's how I interpret it. But you're right in that it's not entirely clear. So ex ante, we don't know. In the next case that comes before the court, I'm not sure we could tell what will be the distinguishing factor. And as Paolo says, I agree that, what is a luxury product and who decides on aura of luxury of a given product.
No, I would like to come back later to that discussion of luxury and non-luxury products because I think it's a very interesting discussion. But I would also like first to ask you, Pinar, something more connected with the e-commerce market. So do you believe that there are stronger or weaker presumptions of legality in this context? Because these questions have typically appeared in the context of e-commerce markets and not other markets. And I think also you have done a point about that, Paolo, so if you want later to chip in as well.
I think I might have to give you the economist answer to that question despite being a lawyer and say that it depends. I mean, yes and no, because...
Sorry, that's the lawyer answer.
No, that's the economist answer. That's what the lawyers think the economist answer is. I think it depends, and yes and no, because in the statements of the European Commission, for example, they suggest that essentially internet sales should be available to anyone in all means, and restrictions on the internet are just per se restrictions, you know, no matter what. Some of the statements suggest that. The guidelines do, and, you know, before Coty, I think that's how Pierre Fabre was interpreted as well. But on the other hand, you know, the Commission guidelines also allow for quality restrictions to be placed on sales on the internet. So, for example, the Commission says that it's okay to exclude an online-only retailer from your selective distribution market just because they're online-only. And that's seen as, you know, equality, again, restraint that the selective distributor or the manufacturer can impose in its selective distribution system.
So it's kind of a balance.
It's kind of a balance, I think. And also remember in the EU and, you know, competition laws modeled on the EU, there's always the possibility of an exception found in Article 1013 in the EU that even if it's hardcore and even if it's a by-object restriction, there is always the possibility to justify it. So that finding of an object restriction is never the end of the assessment.
Yes, but there is a very hard onus of proof, of course. It's very...
Sure. But I mean, let me also say, I mean, in the EU, there is already a distinction between hardcore vertical restraints and those that are not. So this isn't specific to online markets. We know from the block exemption regulation, even though the regulation is only about vertical restraints, some vertical restraints are deemed to be hardcore, not when they're online, they're just deemed to be by object restrictions despite being vertical. So the EU approach is not entirely effects-based anyway. In that sense, I don't think that online vertical restraints are treated particularly differently. In a way, I think the courts are trying to apply the traditional rules in just a different setting, which is the internet.
I see. So now I will...
Pedro, can I add a few thoughts?
Chip in, of
because, yes, you invited me to chip in. And I want to go back also to your first question, because if the efficiency reason for having selective distribution is to get a different balance between price and non-price competition, and the internet is a very powerful tool for competition, and I just got a publication here that seems very interesting. It's an OECD publication that say quality consideration in digital zero price market. And you know, the internet is considered to be a very effective tool to increase price competition. Now, if this is true, the effect of having online sale will be to spur price competition and possibly diminishing non-price competition. So if, you know, rebalancing the two was the efficiency reason in the first place, it is the very efficiency reason to justify restriction on the use of the internet as a distribution model, channel. So the fact that internet is very a system that leads to very fierce competition is the efficiency reason for restricting it. Might seem strange, but if you think twice, that's, the right answer.
A very, very short question. When we promote competition, generally, shouldn't we promote at the same time price competition and non-price dimensions, or is indeed a trade-off between the two? Is there a risk that if we try to focus too much on price competition, we'll forget the quality side, and that will have negative effects for consumers?
There is generally a trade-off. So you cannot get always both of them, at the maximum level. Sometimes you have to sacrifice one of the two to get the other one.
Well, that's a shame. Well, let me then now move to Gunnar. I would like to ask you if you agree with the positions made so far, and particularly to ask you about some of the enforcement experience of the Bundeskartellamt. I mean, we already mentioned the Metro, the Pierre Fabre, the Coty case, but the Bundeskartellamt has also a very interesting case, the ASICS case. So I would like to ask you a little bit about your position regarding what was said so far, and if you could illustrate a little bit as well with the experience of the Bundeskartellamt.
Yes, thanks a lot. Let me first of all excuse Birgit Krueger, who would have very much liked to come today, but I couldn't do it. I'm all the more happy to be here. I would take up something that Fred Chani said in his speech, and that is the importance of facts and also of cases, of investigations. I think the theory of vertical restraints is well understood, and Paolo explained it at the beginning of this panel. But I think it's also important to do cases, to investigate the markets, to see what are the real-life situations that we look at. And we as Bundeskartellamt a few years ago, we saw a sort of renaissance or proliferation of selective distribution systems in all sorts of sectors, and not limited to luxury products or technical goods, the traditional products you would think of. And that, of course, makes you suspicious as an enforcer. And I mean, that was one of the reasons we digged a bit deeper and had the feeling that in some instances these selective distribution systems, and especially online restrictions within, might be a sort of a smokescreen to have a means to follow purely anti-competitive aims, and especially to restrict or to lock out innovative or price-aggressive newcomers. On the other hand, we of course also agree with what Paolo said, that competition is not only about prices, and that some problems that may arise regarding quality requirements, free riding, and so on, might be intensified by online competition, which is often very price-centered. So that as a general remark, and regarding our ASICS case, I cannot explain the case, and a lot of you will be familiar with it.
Just before we go to the case, if I may ask to follow up. So I think we all agree that there is some need to balance. I think the big question is how to balance and how to apply competition law in this case. And I felt that from this side there would be an intention to apply a more effects-based approach. Would you agree with this position, or you think it's better to have a more per se approach, at least for certain kinds of restrictions that are just the standards are too high? For example, if we completely restrict online competition, there is just too much of a risk and no assessment of effects is needed.
Yeah, I mean, that is a difficult question, because I mean, no one would argue with an effects-based approach, which as such is always a good idea. But then on the other hand, everyone wants legal certainty. And I mean, that is a trade-off, and we have the legal framework in Europe with the vertical block exemption regulation, which is in a way very generous, because it exempts all selective distribution systems below the market share of 30%, and which has only very limited safety valves, I would say, so means to do an case-by-case assessment, to really have an effects-based approach. You can, theoretically, you can withdraw the benefits of the block exemption regulation, but that never happened. And it might be the right way forward to allow this instrument to be more feasible in practice. It is not. So the other way to come to a more case-by-case study is to look at the hardcore restrictions, and then very often you come to this feeling that you have a per se rather legality or illegality because it's rather black or white. And I think we, as enforcer, we see the difficulty, but there's no easy way out if you want, on the other hand, you want the legal certainty for the undertakings.
Yeah, so okay, so we can agree that, of course, effects-based is always desirable, but in certain circumstances, maybe it's not practical, or that will generate too much legal uncertainty, and in certain circumstances, the risk is too high that it could make sense to restrict or to forbid some hardcore restrictions, some hardcore vertical restraints. So maybe we could now get in the ASICS case, which we are, of course, very interested.
Just a few words on the ASICS case to maybe also to distinguish it a bit from the Coty case, or to explain the German position, which is always seen as very strict when it comes to platform bans. First of all, our ASICS case was not directed against selective distribution as such. It just dealt with certain contract clauses that, in our view, significantly restricted online sales by authorized retailers within the system. To understand the case, I would like to highlight 3 points. First of all, in the German e-commerce market, intermediaries play a very important role, more than in other member states, which is also a result of the e-commerce sector inquiry by the European Commission. Especially marketplaces are of great importance in Germany. It's not a surprise that for Amazon and eBay, Germany is the second most important market. So that may distinguish the German market a bit from some other markets, even developed markets. Secondly, our proceedings concerned what we called per se prohibitions, meaning that in the contract clauses of ASICS, the use of intermediaries, marketplaces, but also price comparison sites, and the use of the ASICS brand name in search advertising, Google search, were not related to quality requirements. They just stated marketplaces cannot be used irrespective of the quality. And that we found rather difficult. And the third point, when it comes to the reasons why we took up this case, one important aspect was that in these markets, similar restrictions were used by all major manufacturers. So in the market for running shoes, we have Nike, Adidas, and ASICS with a combined market share about 75%. And they all, in a very similar way, restricted online sales. So there we had a feeling that this might also be a danger for inter-brand competition.
So just to clarify one issue, so I have looked recently at the contribution by the Bundeskartellamt for last year roundtable, and they also discussed there in detail the ASICS case, and they discussed there the issues that you're referring to. They mentioned, just to summarize, the 3 main issues, which are the prohibition of third-party platform sales, the prohibition of the use of price comparison websites, and restrictions on online advertisement. So there are indeed many restrictions. There were many concerns analyzed in this case. But if I understood correctly, now please correct me if this is not right, is that in a publication by the Bundeskartellamt about that case, or in the later decision, there were 2 of these issues were fully addressed, fully solved, but the question of whether the prohibition of third-party platform sales was a problem or was not a problem, that was left open. And my question is, was that left open because of the question about was it a luxury product, was it not a luxury product, is the importance of the brand important, is the reputation of the brand important?
No, the discussion around the luxury products and what is meant by luxury products is newer. We didn't discuss that at the time of the decision, but the background to our decision to leave this question open or not to do a final statement on the legality of marketplace bans is rather to be found in the vertical block exemption regulation and the guidelines, and the Commission's position and the guidelines that normally it's not hardcore. So we wanted to leave this to the further development.
I see. So just before moving to the next part on most favored nations, I would like to tell a very short story, and from that, just to illustrate some of these concerns that you have been discussing so far, and from that story to ask one or two general questions to everybody who wants to chip in. So, and this story, believe it or not, was about the time when I bought my piano. This might seem odd, but when I was choosing that piano, I went to a store, and I found the best seller in Paris, and I'm serious. He allowed me to try all the pianos. He gave me a lot of information, press-sale services. He was extremely nice. This is the #1, the best seller of pianos in Paris. I'm not kidding. And he even allowed me to play in a 100,000 Steinway that was in a reserved room, even though he knew that I was not going to buy that piano. Now, at the end, I told him, look, you provide me such a good service, I'm going to buy this piano from you, but I'm still going to do my homework and check the prices in other places. So my question is, if I found a lower price, this is a true story, if I found a lower price, will you be able to match? And he replied, I cannot promise you that it will be the lowest price that you'll find. What I can promise is that I will do the best price that I can make. I kept my promise, and he kept his, and I bought the piano from him at a price that it was not the lowest in the market, but it was close enough. Now, if I was a savvy consumer, I would just have gone somewhere else. I'll just have ordered the piano online, and I would have free ride on all these amazing services that the seller provided me. So, my first general question is, in a world where we restrict a lot all these vertical restraints to prevent some form of online competition, what will happen to the best seller of pianos in Paris? And another more complicated question is, in this context, in this very specific context, which is very illustrative, is it relevant whether the piano is or is not a luxury good? Or instead of questioning that and discussing if I'm buying or not a luxury good, for me it's not luxury, it's essential, but for other people it might be luxury. Instead of discussing that, should we discuss instead whether there is an actual free riding problem in this specific context, and whether that free riding problem could justify some vertical restraints, and whether those vertical restraints are the only way to guarantee that that the best piano seller in Paris will not go bankruptcy. So, what we do?
Well, the story you just told us is very illustrative of the main reason for having a selective distribution, and that gives thoughts for behavioral economics studies. Maybe not all consumers would behave as you did. And I guess that mostly would rationally go there and shop at the lowest price, at the lowest available price. So, and this will definitely give troubles to the best piano seller in Paris. Let me go back to main statement. My main statement is that the right balance between price competition and non-price competition is better understood by the piano manufacturer. It knows whether it is good to push for more price competition or not. And its interest in pushing for the right balance between the two is aligned with your interest. Now, I don't want to get wrong, to be misunderstood. I do believe that there are theories of harm that can be applied to selective distribution models. I'm not saying that they are per se efficient. And going back to your question, whether per se rules should be applied, first of all, I do not think that in Europe, at least, there are per se rules. there are infringement by object, which means something different. So the best way to, in my view, is to have a clear set of presumptions and a clear way to rebut those presumptions, which goes also to the issue of having fair procedure that Fred was mentioning during his speech. So it's not only a substantive issue, it's also a procedural issue. I mean, if we have a presumption that a ban on online sales is an infringement by object, and basically there is no way to overcome this presumption, then it becomes a per se rule, which is not really in line with our system that should allow companies the possibility to improve the efficiency motives behind that.
But then, by the way, this question is for all, of course. We are very interested in the different opinions. But if restricting online sales or a complete ban of, let's say, we tell the supplier, you cannot forbid your distributors from selling online, if that's out of the table, what could the suppliers do to continue providing such good services through these distributors that wouldn't go against competition rules? What would be the alternative? What are the mechanisms available? Or is the piano seller doomed?
I really don't know. I mean, that's up to them. I don't know the piano market so well to answer your question.
No, but we can.
Shall I? I mean, I think your point is much larger than selective distribution models and luxury products and free riding. I think there's a much bigger issue. I had a similar experience. This was a chest of drawers I wanted to buy in Leeds, and I wanted to see it. Specifically wanted to see what I'm going to buy, and we went to a furniture shop, and he almost had nothing at all on display, and I said, where's all the furniture? And he took out the catalog, and I said, but I came here because I want to see it. He said, I can't actually bring them in because it's too expensive. Everybody just buys them online. I mean, and there are now stories, at least in the UK, about high streets turning into ghost towns because it's just not, they can't make money. But this isn't just a free riding problem. It's the result of the fact that it's so much cheaper to sell things on the internet. And it's not just about luxury products, it's about, I think, most things we buy, in a way.
Fair enough, but maybe I can ask this to Gunnar, for example. If I'm a supplier in Germany, I know I cannot forbid my distributor from selling online, but can I tell him at least, okay, if you want to be my distributor, you have to have a showroom, and you have to have a showroom with certain square meters, and to be open at least these times per week. That's minimum. Would this be okay to kind of go around the problem?
Yeah, I mean, you don't have to supply pure online players. I mean, that is common sense and also in the guidelines. And let me add that your little story or your example is about a very specific product. And if we look at the majority of consumer goods, the free riding often goes both ways. Because if I buy a washing machine or whatever, I often inform myself online. And then for some reason or another, I might want to pick it up and take it home immediately. And therefore, I go to a shop knowing which product I want to buy, because often the service and the stationary e-commerce shops, the stationary shops isn't really that good. So, I mean, it's more complex than your, I would say, one-sided free riding example, and it requires of the undertaking, of course, to get to a sort of multi-channel strategy and to combine the benefits of offline outlets and online sales, and I think that is what happens in the markets.
Well, I have to agree with you. My case was very specific, and it was probably one of the few circumstances that happened in the 3 years and a half I have been living in Paris. But still, my point was to ask if it makes sense to look at the specific case to see if there is actually a free riding problem or any efficiency that is very important for the survival of the business model.
I think we should focus more on the upstream market as well. I mean, because we are talking about the effects on intra-brand competition, but there might be negative effects on competition upstream. And possibly this is the, I would believe, the more credible theory of harm applicable in a selective distribution. By adopting a selective distribution system, companies can soften competition upstream. And so if a competition authority wants to prove, that's my idea, its case, it might look at the possibility that that system would reduce competition upstream. Because, you know, in that case, it makes sense to have manufacturer decide to have a selective distribution model to restrict competition in its own market. Then it makes sense.
I will just ask because I feel that at this point I have to move to the next topic, but are there any final remarks that anyone wants to make about this selective distribution apart from... Okay, so no, go ahead.
No, I mean, just to say, because you asked questions about, you know, can I set rules about times of opening and so on. I mean, if you look at the case law in the EU, if they're qualitative criteria and they're objectively applied to everyone, then you can. And I think the real developments we'll see will come in the really in the area between PR, Barbara, and Coty in terms of figuring out what counts as a restriction closer to an outright ban and what counts as a restriction that's closer to a ban that could be justified in some ways. And presumably there will be more case law there which will clarify what part of restriction falls on which side of that essentially balancing.
So that's also a lawyer answer, using a principle of proportionality.
But that's literally what the court says. It has to be proportionate and justified. So.
Of course. So, entering now in the second very interesting topic, let's leave aside now the selective distribution models and talk about something that is even harder than this. And I'm talking about most favored clauses. Now, these most favored clauses are basically a promise by a seller to treat a buyer as favorably as its best buyer. So this means the seller cannot set worse conditions than it set somewhere else. Now, in the context of e-commerce, most favored nation clauses have been used in many instances by online platforms, and this discussion came up over and over again regarding online travel agencies. So in several circumstances you have companies like Booking.com, Expedia, basically saying that, saying to their sellers, to the hotel chains who put the prices in their platforms, you cannot put worse prices or higher prices in our platforms as compared to the price that you set in your own website or in other platforms, depending on whether these clauses are wide or narrow. And the main objective here is again to prevent the problem of free riding. So all the discussion just had about the piano store, it also happens in the online world. So there is a concern by these platforms that savage consumers just go online, use Booking.com or Expedia to check the different alternatives, and then after having a good service full of pictures and conditions and comparisons, they just go somewhere else to book the hotel. Now, this time I would like to start with Pinar, because Pinar has published a lot specifically on this topic, and when you came here 1 year ago, we already discussed back then a paper of yours, I believe that was on the Journal of Competition Law and Economics, and now we have a new one, a fresh one that was just published in the end of last year in the Review of Industrial Organization with Daniel Sokol. And so, what I would start by asking you is, first, what's your review about these most favored nation clauses? Do they pose concerns that, do they pose serious concerns? How to balance their efficiency gains against their theories of harm?
Again, it will be yes and no answer, I'm afraid. I mean, just maybe to clarify for the sake of, I suppose, making sure we know absolutely what type of clauses we're talking about. So, as you described, with a normal MFN clause, you have a particular seller who is supplying the same product to different customers, and the customers that come after the first customer want some reassurance that they're going to get as good a price as the first customer and so on. So that sort of MFN, which is what we saw commonly before these platform MFNs became an issue, links prices of the same seller for different customers, Whereas with the platform MFNs, it's a lot more complicated or complex, where the platform MFN links prices for the same customer who would be potentially buying from competing outlets, essentially. So in some ways, the platform MFN actually fixes prices found at different competitors for the same customer.
So basically, what you're saying is that in this context of online platforms, the MFNs result in price parity agreements in equal price.
Yeah,
they're a lot closer to price.
Sorry if I step in, but you know, that's one of the biggest failure I had. One of the many, but we advocated as LAIR, we did a study for the OFT, and we advocated for using a different name, we call them APPA, a cross-platform parity agreement. And the main reason was that we wanted to avoid any confusion with MFN, which is a totally different arrangement. Completely different. And there is no real connection between the two.
I had the feeling that I would have problems for using this term with both you and Pinar, because you usually use the term price parity agreement.
And we failed. I mean, we keep calling them MFN.
But the contracts call them most favored. Well, they don't call them most favored nation clause, but the contracts of the platform speak of being treated as favorably, essentially having as good prices. So in a way...
So usually use the term most favored customer clauses to try to...
But they don't specifically use that, but the way they explain it in their contracts is very similar to how an MFN would work. It's just the complication here is the platform is an intermediary, and the benefit of the clause is received by a third party, not the party to whom the promise is given, which is the platform. It's the consumer that receives the benefit rather than the contracting party who receives contractually the benefit of the promise. So, I mean,
so no, I must apologize for using this term. I knew I would get myself in trouble, but to be fair, everybody knows these clauses by this term, and in fact, this distinction is a distinction that is very important to understand when you're talking about something that is probably unproblematic, and when we're talking about something that could raise competition concerns.
But even normal MFNs can raise competition problems anyway, because they also lead to essentially diminishing the incentive to reduce price, because once you have promised to someone, every other seller is going to also get the same price. You have obviously a lower incentive to reduce price to anyone, because you'll have to reduce the price to everyone else who comes next as well. So normal MFNs can also have very similar effects. It's just with platform MFNs, I think the effects are closer to what economists have been studying as price matching guarantees, rather than normal MFNs, and the literature on price matching guarantees in economics is a lot more developed and suggests that actually these are more likely to be anti-competitive than MFNs.
Yeah, I mean, they are not necessarily the same, but many of the theories of harm are pretty much similar or even the same. So to be clear, we are talking about MFNs that result in price parity in the context of online platforms, and the usual theories of harm about this now I'm afraid of using the term MFN, but the usual theory of harm associated with these clauses can be that they could facilitate tacit coordination, they could reduce inter-brand competition, they could result in the exclusion of potential entrants. For example, if a new platform wants to provide services to hotels at a better price, it will not be able to gain market share because the hotels still have to set the same prices as they do everywhere else. So there are all these theories of harm. Now, I know I did you a very general question just to warm up. I'll do now a very specific one instead. So, now, in your last paper, you said that enforcement across jurisdictions has been based on economic theories that not always match up with legal doctrine. So I just have summarized a little bit the economic theories. Could you explain us why they are not matching up with this legal doctrine? Very briefly.
That's going to be very difficult to explain briefly. I think is this the paper with Denis Sokol?
Yes.
Okay, let me blame him. I think what we probably were referring to was essentially the outcome, or our conclusion in that paper was looking at all these investigations into platform MFNs and also online resale price maintenance. So we did both in that paper. We see that actually in some of these instances, particularly for some of the online RPM cases, there's nothing new here. It's just resale price maintenance applied in an online context. There's nothing specific about these that would necessarily require different treatment. Whereas with some others, like platform MFNs, the fact that this is a two-sided market, it's online, there's certain price transparency and so on, might actually require perhaps a different assessment. But what our conclusion was that there's lack of clarity when we look at the decisions, sort of across the range of decisions from many different jurisdictions. There's a lack of clarity in terms of whether these cases concern A, a vertical restraint, B, a horizontal restraint, C, is it a restriction of intra-brand competition, or D, is it a restriction of inter-brand competition? And when we answer any of these, about which market are we talking? So on which market, competition between whom do these clauses restrain? And we saw that there's some sort of really, it's not necessarily a confusion, but a mixing up of theories of collusion with foreclosure. Some cases which you would think should have been pursued as hub and spoke cases that were actually pursued as just vertical restraint cases with a horizontal theory of harm. So that was really what we were referring to in saying, okay, in economics, you would be looking at the effects and you would saying, okay, this looks like collusion, this looks like foreclosure, or it might be both. But in the legal cases, it seems like some of this has been mixed. So it might be a foreclosure case, but the legal tool used would have been a rule against anti-competitive agreements and so on.
So then we apply the 101, for example,
yeah.
even though the theory of harm is matches more a foreclosure, abuse of dominance case, for instance.
Or you apply 101 in a vertical restraint context, and obviously that in the EU that opens up the possibility of applying the verticals block exemption regulation. But really, when you dig deeper into the decisions, the main concern appears to be actually collusion between platforms, but none of the decisions have ever actually alleged any collusion between platforms.
Mm-hmm.
So just a very short follow-up question before, because I now would like to move to Gunnar. So I would just like to ask you, in light of this mismatch, do you think there is a lot of divergence in the application of competition law to these MFN cases?
I think there has been a lot of divergence in that one company in particular is now subject to at least two different rules, maybe more because there's been legislation as well. Booking.com in its contracts is now subject to per se ban of all of its MFN clauses in some jurisdictions, or a partial ban of its wide MFNs, so MFNs that reach for parity across all platforms and all sales channels, but it can still apply its sort of so-called narrow MFNs. And I mean, for legal certainty and business certainty, obviously this can't be really.
Well, I would like to go later now back again to the narrow and wide clauses, because I also think that this distinction is very important and relevant. But first, I would like to ask Gunnar, do you agree that there is a divergence of approaches across authorities? Is that important or it is not? And if there is, does the Bundeskartellamt has a consistent approach? And what, so what's your views on that?
The last question, of course. We have a consistent approach as Bundeskartellamt. No, but I also think that this discussion about the convergence within the ECN or within Europe seems a bit excessive to me, because we have a broad consensus that that wide MFNs, I would call them like this because everybody does, that they are problematic from a competition point of view, which might even justify thinking about making them a hardcore restriction in the view of some. And I think that is an issue that will be discussed in the ongoing discussion on the vertical block exemption regulation. And that narrow MFNs, I mean MFNs that relate only to the own website of the hotel, if you look at hotel booking platforms, that they have to be analyzed more on a case-specific basis. And I think the divergence in these cases was, to a large extent, due to priority setting by the authorities, meaning are we willing to invest more into these cases and to further investigate the effects of these narrow MFNs and go to court with this, or are we happy with a quick solution? And I mean, some decided for the quick solution, and then later the national legislator said we are not happy with that, and we will now ban all MFNs, yeah, which was the case in I think in Italy and in France, and others like us, we followed on and did the case also regarding narrow MFNs, and our case is still pending in court, so we still have trouble with this case, and I think this was the basic difference, and then you also have to see that market circumstances, market conditions were also different in different member states, depending on if you have rather a landscape with small hotels or big chains, because that might have a huge influence on the possible free riding issue.
So actually, this allows me to ask a question back, because both from Pinar and Paolo, actually, and from you as well, this was one of the points that was quite consensual. An effects-based approach is usually a good approach, generally. But if we implement, for example, systematically an effects-based approach to these MFNs, shouldn't we expect some divergence in the decisions, because the circumstances in countries would be different, and the hotels, the hotel market will also be different in different geographical markets? This is a general question.
I don't think this explains the divergence in outcomes that we saw in the Booking.com case. I do not read in the decision a very detailed description of the market that could justify a different conclusion. So it was a different reading of the extent of the prohibition, probably.
Now, well, since you are on, Paolo, I have a very specific question for you as well. Okay. Because I have found a symposium that you have done on competition and law and policy debate, I believe, in Belgrade. And back then, you discussed a little bit the importance of building the theory of harm based on factual assertions and logical propositions. This was from you, right? Yeah. Just to make sure.
I recognize.
So, I will, in light of this diversion that you just discussed and all these rising difficulties, again, briefly, how would you advise, as an economic advisor, what do you believe are the most important factors when building a theory of harm in these cases? How should the thoughts and be organized and structured?
Well, the first thing is to understand the strategic effect of this kind of clause, and the main effect. And to recognize that the main effect takes place in the platform market. If you have a parity clause, if platform A has a parity clause, what I call a parity clause, this means that sellers that operate on that platform and on a competing platform cannot charge to the end buyers a lower price on other platforms that charge to the seller lower platform commission, for instance. And the effect of this is to reduce the demand elasticity of the platform. So basically it means that a platform that lowers its own price has a smaller reward. Okay, so there is less reason for being aggressive on the platform market, charging lower prices, and this is the main ingredient. I mean that this is a fact. So I don't think that there is anyone that would question this fact. But this is the ingredient that can be used to build a theory of harm, or even an economic justification, efficiency justification. And the theory of harm can be that either that the upstream market, the platform market, I wouldn't say the upstream market, the platform market is less competitive, so it's a softened competition theory of harm, or that a dominant platform could prevent a new platform to successfully entering the market with a business model in which it charges a low commission to sellers. And basically, the same fact can also be used to build an efficiency story. And the story here might be that a new platform wants to use the parity clause in order to avoid that the incumbent use prices to push the new entrant out of the market. And so that's the fact we have to recognize and then see which theory of harm or which efficiency justification is more likely to be coherent, consistent with the characteristics of the market. So if there is a dominant company, dominant platform, probably the foreclosure theory of harm is the most plausible. If there are several platforms with equal market share, for instance, then the softening combination theory of harm is more likely. And if the parity clause has been adopted by a new entrant, then the efficiency justification seems reasonable.
As we are getting short on time, I'll just now ask a question to Gunnar. I'd like to ask if this approach has been used, or if the Bundeskartellamt has a very different approach, and in particular, for example, in the context of the case HRS. So there are a lot of cases about Booking.com and Expedia, but this is a case that actually the Bundeskartellamt has enforced. So could you tell us about a little bit how you built, how the Bundeskartellamt built the theory of harm in this case, and if it diverges a lot from, for example, what Paolo said?
No, I totally agree with what Paolo said about the theory of harm. And in the market in Germany, we had three main players at the time, which were HRS, a German player, Booking.com and Expedia, and all three of them used this sort of MFN clauses. So our story was a story of a softening of competition, and at that time HRS was the most important player, so we started with HRS. Nowadays, of course, Booking is overtook them and are by far the most important. And I think there's not much discussion about the theory of harm. There has been more discussion when it comes to efficiencies and to the problem of free riding. And I think that really is an interesting topic, because from a theoretical point of view, there might be free riding, as has already been described on this panel. But if you look at it, look at the facts of the case, there's actually very little free riding, even surprisingly little free riding. As I mentioned, our Booking case is pending before court, and the court gave us some homework to do, and so we had to investigate, and we made a consumer survey, and we asked the hotels and the platforms and everyone, and the results are rather striking, because I don't know the actual numbers, but nearly everyone who finds a hotel on a booking platform does the booking on the platform too. And of course, the larger hotels and hotel chains, they have their own real-time booking possibilities, but they are mainly or only used by regular guests that already know which hotel they want to go to. So there's a clear-cut distinction between these two customer groups, and I mean it's even more shocking because consumers are much more lazy than you would think. They do not even modify the ranking on the first page of Booking or whoever, but most of them even book one of the first 4 or 5 hotels that they see. So, I mean, with such customers, obviously the free riding issue is not that important.
So just to be clear, the Bundeskartellamt actually looked at the evidence of free riding in this specific case, and which appears to be much smaller, the level of free riding, than as compared to other markets, for example, the peanut market, where the free riding might pose a bigger problem. Just a very small follow-up question. This assessment of the evidence of free riding was, of course, made in a context where these most favored nation clauses exist. So is there a risk that if they are left free riding could...
No, for the moment, Booking is not allowed to apply the MFN clauses. So we have a sort of real-life experiment at the moment, and Booking got stronger and stronger in the last 2 years. So I think these clauses might not be that important.
Free riding
Can I ask you if you checked whether the hotel do charge lower price on their own platform?
Yes, some of them do, and I mean that has also been assessed by the European authorities in an ECN working group very near to the decisions, and there we saw not so huge differences between the member states which accepted the commitments and in Germany. And today we see that there is a bit more of price differentiation, but I would say not to a large extent.
Can I just throw a spanner in the works before we break for coffee, maybe? I mean, I don't know if Booking.com still does it in Germany. I suppose they might. But one thing we haven't mentioned is that they don't just have MFNs with hotels. They also have a best price guarantee on their website to consumers. It says on Booking.com, we will not be beaten on price, find it anywhere else cheaper, and we refund you. So if the consumers have seen that, they are sort of resting assured that the price they find is cheaper. And the interesting thing is all of the platforms have the same clause, HRS, Expedia, Booking.com. And even more interestingly, this clause hasn't been subject of any of the enforcement decisions. And actually, Booking.com put it in its commitments with the Swedish, French, and Italian authorities, in which it legalized the clause by saying we will continue to apply our best price guarantee to our consumers. So you were talking about the effects-based approach. I mean, if you don't adopt an effects-based approach, there's a possibility that you will overlook those other things which might actually have the same effect as the clause one is investigating.
So what you're saying is that this MFN clause, in the context of this MFN clause, it's very important to see if any other auxiliary practice are occurring, if apart from the MFN clauses they are doing something else that might reinforce the anti-competitive effect of the MFN clauses.
Indeed. I mean, if they're anti-competitive, they'll be made more anti-competitive by the best price guarantee, and if they're not anti-competitive, I guess it's a good price, guarantee to consumers.
So, as this session starts a little bit later, we still have a couple of times just to see if the audience has any questions. I'm afraid to say that we'll only be able to take a few questions. And just as back in college, I'll give the advantage of at the front rows to promote people sitting in the front rows instead of the back in the room. So, are there any questions to the expert speakers? Please, not to me. Okay, the last rows can also ask questions.
There is one.
Mike?
Only a few questions. The question of luxury. It's one of the most difficult issue to define what luxury means. In antitrust perspective, it could make sense to exchange the concept of luxury in order to justify selective distribution in terms of services that require post services or other services that justify a restriction on price competition. So not to use this concept that is so difficult to define, but something that is linked with a real service needed that could be destroyed with a pure price competition. Thank you.
Well, I never use the word luxury or reputation, whatever. I just refer to price and non-price competition. Then I would leave to the firms to decide what non-price competition dimensions are important to them and to consumers. So that's the simplest way to handle your question.
Well, any further questions from the floor? Please.
So following up on the same questions of luxury, what Veblen concept of goods? No competition can have anomalies. This is what economists call Veblen. So a situation where the law of demand and offer, it's not following the paths. So what about this, and is it this a sign that perhaps we are in a straitjacket because we want to simplify things and give certainty to the companies, but things are much more varied in practice? Thank you.
Is it for me?
Well,
I doubt that Veblen product will ever be sold through a selective distribution system, if I understand correctly your question. And there is, yes. So in those cases, we probably do not have reason to be concerned in the first place, because there is not a selective distribution arrangement.
Well, Pinar Akman, if you want to intervene, of course, feel free. And I think we have at least time for another question, maybe not related to luxury, or yes, I made myself many questions about luxury. Oh, yeah, please, go ahead. Sophia? Okay, so we have more these two questions, one from the center and from the side.
Hello, Suzanne Jude from Core International. I was wondering whether we had any news on the working group formed after the Booking.com case with the 10 NCAs were supposed to look at the evolution of the market. There was a first intermediary report in France that was a bit disappointing, that suggested that, well, say for Booking.com's competitors, everyone was pretty happy with MFN's hotels and consumer included. So will we have a final report at some point?
As for the moment, there are no plans to make another report in the coming months or so. But we have still our case before court, and as I mentioned, we have some new interesting insights on how the markets developed. And I think when we are through with this court case, we will of course publish a bit of this.
Thank you.
And last question from there, from the side.
Paulo Casagrande from Brazil. Gunnar mentioned that an important issue in having a more strict stance in the evaluation of vertical restrictions in the online sector was that in Germany, marketplaces were very relevant for overall commerce. Would this kind of specificity in this or that country be important in the evaluation of vertical restraints in the online sector for other countries? I mean, do you see this as being an important ingredient in evaluating vertical restraints in other jurisdictions, the relevance of e-commerce or marketplaces specifically in the overall segment of commercialization of goods? Thank you.
Which of you would like to address the question?
I mean, I think it is important to have the possibility to take account of the circumstances in your country, in your national markets. What's a bit under discussion is what does it mean if you apply the European legal framework, especially the block exemption regulation. Can it be that a certain practice is a hardcore restriction in one member state and not a hardcore restriction in another member state, which is, of course, a bit difficult under this framework. So that's why I said if there are other ways to take into account the circumstances in your country, for example, by withdrawing the benefits if you see that competition does not work properly in your markets, that would be, from my point of view, would be a better way. But if we do not have this, I mean, there must be a possibility to take these specific circumstances into account. And I mean, it cannot be that you just look from a European perspective and say, okay, if there are a lot of member states where platform bans are no problem because we have no platforms. That doesn't help us a lot in Germany, I would say.
Well, I feel this has been a very interesting discussion, but now that, unfortunately, I'll have closed it because, as I have seen, not only the speakers were fully engaged, but also the audience fully engaged. And at the beginning, I started by saying that I was going to open 2 Pandora's boxes, and I think I did. Now, when Pandora opened her original box, which was not a box, it was a jar, by the way, and unleashed all the evil in the world, she tried as much as she could to close the jar. And the only thing that was left was hope. And I think that from this discussion we see that there is actually some hope of finding some agreement in the legal treatment of vertical restraints within e-commerce markets. So thank you so much, first of all, to all the expert speakers for engaging in this very interesting discussion. And in the next session we'll continue a discussion of a very important topic that was mentioned here in a few cases, so the importance of non-price competition. And so we'll have to make a shorter break of only 15 minutes to keep back on track. So if you could be back in the room by 5 to midday, so that we can start sharp at least at midday, so try to do it at 5 to midday. And again, thank you all very much.